This webinar is going to be a little bit different than some of our other webinars. The main purpose is really just to answer all the questions that you all have about what the FDA has announced recently. We're going to focus on the menthol rule. If you're not signed up, we do have a webinar on the cigar rule tomorrow. So we'll do this same exact thing on the cigar rule tomorrow. So Mike and I will talk for a minute briefly just to sort of get things going. And definitely feel free to start just peppering us with questions in the Q&A. We'll start with sort of talking about what's in the rule, what's not in the rule, and then try to focus on helping you think about what issues to comment on and hopefully clear up as much of the uncertainty as we can about the FDA's process. I will say we're not really going to talk about the background of all the stuff that got us here today. We do have a ton of resources on our website. We have a really cool timeline that Stephanie and others have put a lot of time into to create. And then we have other resources that are like the mechanics of submitting a comment and that kind of stuff. So hopefully you've been to our website since you're here in our webinar. So if you go to the FDA or the Federal Tobacco Action Center, you'll see links very close to the top for menthol and for cigars, and then all of our resources for that stuff is right there. And Stephanie's already dropped it into the chat because she's on the ball. So we can start kind of digging into the rule. And Mike, do you want to kick us off?
Yes, thank you, Desmond. What I would like to talk about is what I consider a significant aspect of this milestone. And that is that the FDA rooted its decision in health equity. The document mentions equity 18 times, perhaps a record for a document emanating from the Center for Tobacco Products. And it begins with the following statement. Advancing health equity is a policy priority and an important component of fulfilling FDA's mission to protect and promote public health. FDA and the federal government now recognize that the advancement of health equity is both a moral imperative and a pragmatic policy. Now, as you know, the FDA had authority to ban menthol since the passage of the Tobacco Control Act in 2009. It only had to determine that such an action was, quote, appropriate for the protection of public health. But we did not get a menthol ban until 30 years after Congress gave the FDA this authority. In any case, the rule spends a significant amount of time explaining Congress's initial exemption of menthol, the Tobacco Control Act, and FDA's delay, these twin original sins in the act. And it says it hurt a lot of people, most of them African Americans. As you know, some 85% of menthol users are African Americans, but also others like people in the LGBTQ community were hurt by the exemption of menthol and by the delay in this rule. In essence, what the FDA is saying is that the menthol ban is a remedial in nature. It's to correct those past harms and to prevent future disease and death. Now, at PHLC, we believe that equity is an inherent part of public health and public policy. So it bodes well for the work that we do in tobacco control that our government now has come around to this view. Now, the scientific community had long agreed that menthol was crucial to initiation and a determinant to efforts at cessation. But it took the work of many in the public health and tobacco control community, the pressure from organizers and allies to center health equity in federal public health policy. But now is not the time to rest on our laurels. As you know, the tobacco companies are well funded and have fought us every step of the way, and they'll keep fighting us. This ban represents about 1/3 of the tobacco market, and they'll fight us with disinformation. As we've already seen, tobacco companies asserting that a menthol ban will lead to criminalization and more police violence on Black bodies. This is false. The FDA is not a law enforcement agency. This ban is civil in nature and will be enforced against manufacturers, not individuals. As you know, in your own work, when localities have banned menthol on the state level, there has not been one arrest of an individual for possession of tobacco products. Also, tobacco companies recently also went on a media blitz about the economic impact on state loss of revenue from the sale of menthol tobacco product. They said nothing about the billions that will be saved in healthcare costs and in people living full and productive lives. They're shameless and will use our legitimate fears and concerns against us. And they'll fight us in courtrooms and in halls of Congress. And they'll fight us with newer and newer products, but we must not surrender. We must keep the pressure up by responding to disinformation with truth, by engaging policymakers, by educating the communities we serve. And we can start today by sending comments to FDA about the rule and how the menthol ban will affect our communities. Now, I'll turn this over back to Desmond to discuss what in fact is in the rule. Desmond?
Great. Yeah, thanks, Mike. And yeah, I think just to reiterate and highlight what Mike said, I think it's really important to recognize that the FDA sees this as the health equity measure that it is. And I think for a lot of us, that's a breath of fresh air from the Center for Tobacco Products. That's not necessarily the way that the federal government operates. But knowing that they understand that and are working towards that with all of us is really good. It's obviously disappointing to everyone that it took this long, but the fact that that is sort of the guiding principle here is really good. We cannot probably undersell that part of it. So, and I see people are putting questions in the chat, and I see those, and that's definitely some questions that we will get to. Feel free to keep going. So let's start with like, what actually does the rule do? And that part is actually really simple because it more or less just fills the gap that was in the statute. So people probably know back in 2009 when the Tobacco Control Act was passed, the law prohibited all characterizing flavors in cigarettes except menthol and tobacco. And so this rule uses that same language. It says it's prohibiting characterizing flavors in cigarettes. It's prohibiting menthol as a characterizing flavor. So it's essentially just removing that exemption for menthol. The FDA has not defined the term characterizing flavor in the actual language that ends up in the Code of Federal Regulations. They do give us some information on how they're going to think about characterizing flavor and how it will be enforced. But the way that the FDA has structured the law is to really think about which products have menthol as a characterizing flavor as kind of an ad hoc review, which is, of all of the ways that the FDA could do it, is probably not the best, not the most efficient, and not going to have the greatest public health impact. So as you're thinking about comments, one thing certainly is to address that issue of how does the actual rule get implemented. To FDA's credit, they are sort of asking the question, should we just prohibit menthol as an additive entirely rather than trying to determine what is and isn't a characterizing flavor? And so if you think about, well, hopefully people are familiar enough with the evidence base that they know that almost all, or maybe even all, cigarettes in the United States have some menthol added to them. And it's a much smaller percentage of the market that are products that are advertised as menthol cigarettes. So all the products have menthol added in them. So if you remove menthol entirely, and not just at the characterizing flavor level, you're going to affect a broader range of products and have a much bigger public health impact. There's a reason they put menthol in cigarettes, right? And we all know what it is. And so making all cigarettes less appealing and less palatable is going to have a bigger public health impact than just the cigarettes that are advertised as menthol. So yeah, I mean, that's really is the guts of the rule in terms of the content. The FDA is also thinking about the sort of components and parts that might also impart menthol as a flavor. So I know in Canada, they had things called menthol cards pop up. basically a little card that you slip into your pack of non-menthol cigarettes. There's menthol on the card that sort of off gases onto the cigarettes, and so imparts a menthol flavor without them being menthol. FDA is thinking about that and recognizing that the rule would cover something like this, because FDA can regulate the components and parts of tobacco products as well. And then there are a couple of things that are either not in the law, or FDA's asking questions about things it didn't propose but is considering proposing. And a lot of those we would consider to be exemptions. And in tobacco control, I'm sure people know exemptions are pretty much universally bad. They're never beneficial. So the things that FDA is thinking about exempting, but again, hasn't proposed to do so, are exempting products like the very low nicotine cigarettes that have menthol in them, or products like IQOS, so-called heat not burn products or heated cigarettes, that companies say are less harmful. And then FDA is also sort of thinking about into the future whether it should create a process that would allow manufacturers to like sort of apply for a one-off exemption, which, if you've followed FDA's administration of the pre-market review process at all, is an exceptionally bad idea. So those are issues that are also out there for FDA to consider, so certainly other ones to comment on. Mike, am I missing anything that you can think of before we kind of talk about process or anything like that?
Well, no, I think we cannot overemphasize the importance of authentic engagement from communities most impacted by this rule. I think comment early and comment often. The FDA needs to hear how this has impacted your community, and you know, we are available to help you with that work. Another thing that I will also emphasize is, you know, local action on the state level and the local level should you should keep going, because it takes a long time for the FDA to implement these product standards, and of course there's I said earlier, a huge likelihood of litigation, and as you know, that takes years to resolve. So those are the 2 points that I would add, Desmond.
Yes, no, thank you for raising that, Mike, too, because I think if you take anything away from this webinar and any time we talk about FDA regulation, it's that you should definitely be engaged with the FDA, because they're doing what they're doing, and if we don't engage with them, we know the industry will, and if we want FDA to do well, we have to be engaged. But the other thing is the FDA's timeline for action on everything is so much longer than we would probably want it to be, and so much longer than what happens at the state or local level, that you absolutely cannot just stop doing what you're doing and wait for the FDA now that they've proposed a rule. So that maybe gets us directly to the question about how long will this take? And I like the way one of these questions is phrased, is like, what's the best case scenario? What's the worst case scenario? So in terms of timing and the FDA's process, the best case scenario. So right now we have the proposed rule. It was published today. It is officially out there today. And the comment period starts today. It's 62 days, actually, not 60 days, because of the July 4th holiday. So the comment period will close on July 5th. And then after that, FDA will start reading comments. There is no requirement either set in statute or in FDA's procedures on how long it can spend reviewing comments, or how long it can take between a proposed rule and a final rule. And there is no requirement that FDA even get to the final rule. So the worst case scenario, I suppose, is that the 60-day comment period ends and then nothing else happens. Now there's litigation on this issue, and so which we have a lot of resources about, and you know, try not to muddy the waters with that. But I would say that the scenario where FDA does nothing into the future is probably not likely because of that litigation as a lever. But in terms of the best case scenario, I think in terms of what I've seen over the last 10 years, the reasonable best case scenario would be FDA getting a final rule out the door about a year from when the proposed rule came out. I mean, that would be pretty fast. If you remember, if you were doing this back in 2014 to 2016, the deeming rule, the proposed rule came out in 2014 and the final rule came out in 2016. So that was about a 2-year process. And I don't know if I'd say that is more or less complicated than this. It's different. So 2 years wouldn't be a crazy amount of time in terms of what the FDA does, not in terms of what it should be. And then as we maybe didn't say yet, but the FDA is proposing a 1-year implementation period. So that means once the final rule becomes effective, the day that it's published, it wouldn't be a year from then until the ban would actually be something the FDA would be enforced. So at that point, we're talking about, March, April of 2024. So very far into the future. And that's assuming that litigation doesn't slow down the process at all, which seems unlikely. So it's a long process. So if you are have a coalition in your local jurisdiction and you're thinking about menthol, hopefully that makes it clear you shouldn't just decide to wait because the FDA might do something in the future. We're still very, very far away from that happening in the best case scenario. Let's see. Yeah, go ahead, Mike.
Well, I think another thing that folks should know is that the things that are not covered in the rule. Do you want to touch on that?
Yeah, so I have this in my notes too. So to make sure people know that, because I got a question earlier this week on roll your own tobacco, and the regulatory definitions that FDA works with are interesting. And so roll your own tobacco actually falls under the category of cigarettes. So this rule reaches menthol roll your own tobacco as well, and other flavors of roll your own would have been prohibited back in 2009. Nothing in this rule applies to cigars, but there is the parallel rule that we'll talk about tomorrow. Neither of those rules address e-cigarettes, which is another question we've been getting. E-cigarettes are not in the proposed rule. And if we haven't gotten already, I thank you for keeping to submitting questions because there are lots of them. I'm trying to make sure we get through all of them. If we haven't gotten it, I'm sure we will. Should we comment on e-cigarettes? And I will say, if it makes you feel good, you can, but it's not going to end up in the final rule. And that's because when you have this notice and comment process, part of the reason for the structure of this process, as opposed to the legislative process, is that everyone who the rule might impact is on notice that the FDA is going to do something. So if you're an e-cigarette manufacturer, you see the proposed rule and it doesn't touch your products, you're not going to be engaged in the comment process because it's not going to matter to you. So it's unfair for the FDA to depart so much from the proposed rule in the final rule. And so I think I can pretty safely say there's no way that e-cigarettes are going to end up in this final rule, nor would they end up in the final rule for cigars because it's just not even addressed. However, because FDA is in the process of implementing pre-market review for e-cigarettes, it certainly has a vehicle to deal with flavors, but it won't be in this rule. If you put it in your comment, FDA will read it. And if you have information that maybe they're not reviewing in the pre-market review process, it could serve that purpose. But don't put that information in your comment thinking and hoping that maybe e-cigarettes will end up in the final rule, because they just won't.
Now, there's a question here about how long tobacco industry challenges to the rule will take to play out in the best and worst case scenario. I can engage in speculation, but that would be just that, speculation. I mean, they are, as we said, very well funded, and they'll fight this up and down the district court, all the way to the Supreme Court, as we've seen in other litigation. As we saw recently with the pre-market review, they'll file in multiple jurisdictions. So they're not litigation averse, and So it's very hard to say how long it will take. But again, this brings us back to what we said earlier about keeping doing the work in your own communities. Because again, so we're looking at if magically there was no litigation, at least 2 years, but since we know we don't engage in magical thinking, it will be two more years after the 2024. So it will take a long time.
Yeah, it's impossible to say when it comes to litigation, and you're going to get that answer from every lawyer about any question related to timing and litigation. The one thing probably to keep in mind, I think we are fairly used to being on the losing end of litigation, unfortunately. And a lot of times it's because the policy at issue, things like warning labels, there's a hook for the First Amendment, and First Amendment litigation tends to go poorly for the government. The way litigation plays out here probably looks different. And in order to stop the rule from being implemented, hopefully the bar is a little bit higher, or at least it's a little bit harder for the industry to demonstrate the amount of evidence that would be required in order to temporarily put a rule on hold. But as Mike said, there's really no way to know. I saw.
Go ahead.
Go ahead, Mike. Go ahead.
Other question about saying, didn't know that all cigarettes have some menthol in them. I didn't think this is well known and sounds like it has major implications that go beyond the banning of Newport. I completely agree with this question. Because of the soothing effect that menthol has, it's used as an additive in most every cigarette, so that it makes it easier to get hooked smoking, and it makes it harder because of the properties of menthol. It also makes it harder down the line to stop smoking. And so, it is something that most people don't know, and as part of the public education aspect of this work, it would be something that if more people knew, there would be more engagement on this issue.
Yeah, I think that's true. And I see a request for the citation on that. And I don't have it off the top of my head, but I can tell you, if you go back to our original 2013 petition to the FDA, which was granted, and that's why we're here now, you will find at some point, I know we discussed the issue because we had a healthy debate among public health groups at the time of whether the petition should request that the FDA remove the exemption for menthol, which is what they've done, or whether they should remove menthol as an additive entirely. And at that point, after talking with a lot of people who know the science better than we do, we decided to petition for the removal of menthol as a characterizing flavor. But I know there are a number of studies in there that talk about the menthol that is in cigarettes that don't have menthol as a characterizing flavor. In fact, I recall one where a group sort of looked at all the cigarettes on the market and the menthol content of them and sort of laid them all out. And there's a clear division between the non-menthol cigarettes and the menthol cigarettes in terms of the amount of menthol. And so that's another avenue the FDA could have pursued, which is to actually decide what the threshold is for characterizing flavor. They could decide on the precise amount of menthol in cigarettes that is or isn't allowed. And so that's another reason that the lack of defining the term characterizing flavor is frustrating. And so I think, and I see Jeff Fong has some questions and comments on this too. So I think there is enough information out there that can be submitted to the FDA and explained better by the people doing the research, that just eliminating menthol entirely. Let's forget about characterizing flavor. Let's forget about, what level has what impact on the human body. Any menthol is making the cigarettes easier to use, even if it's not at a point where you can taste it. And so there's no reason for the FDA to not go all the way on this. It seems as though that would also be easier for them to enforce. If you have characterizing flavor as your defining feature, and you have a pack of cigarettes and you have this sort of wishy-washy way to explain what is and isn't a characterizing flavor, that's going to be harder to explain to a court. But if the issue is any added menthol, any amount of menthol in those cigarettes other than what's naturally in tobacco is clearly added and clearly a violation. So it creates a much easier enforcement dynamic, in my opinion. Yeah, I don't know, Mike, if you have anything else to say on that. I was going to talk a little bit about the implementation period as well, but there's probably lots we could say about characterizing flavor.
There's a question regarding the enforcement. Who'd become the enforcement arm of this ban?
Sure.
And going back to what I said earlier, this ban is enforced against manufacturers. So basically, this ban is saying manufacturers, you can no longer put menthol in tobacco products. So it would be the FDA. It would be a civil enforcement by the FDA.
Yeah, it's hard to explain how really discreet and simple this can be. The US cigarette market is very insular. Almost all the cigarettes consumed here are made here, and almost all the cigarettes made here are consumed here. And there really are two manufacturers that make up the vast majority of the market, Altria and Reynolds. And this is not a situation like nicotine reduction where you have to really figure out how to make things happen. All they have to do is remove the part of the manufacturing process that adds menthol to the cigarettes. It's an asking you to do less, not do more, right? So in terms of implementation, it's a very simple thing. I know Jeff Fong on the webinar that the plaintiffs hosted yesterday was talking about this too. A 12-year implementation period for this is just way too long. Essentially, you're allowing products to sit on shelves and more cigarettes to be manufactured, because most retailers will turn over their inventory of cigarettes in a few months. So that really should be the longest period of time you'd have. There's no reason to have more menthol cigarettes coming off the manufacturing line after the final rule has come out. And if we wait a full year, that's essentially what we're allowing to happen.
As a sort of a part of what the tobacco industry does when we discuss this issue is they bring the red herring of a black market flourishing, and there has been no evidence of that, but that's something that they trot out every time there's any sort of regulation of any type of commercial tobacco product. So that's also something to watch out for.
Yeah, absolutely. So I think it's worth sort of hitting the red herring issues one more time as well, because I think the over policing and the illicit trade issues tend to get muddied together, and both of them are, the industry knows that they are not going to have the impact that they are saying that they would. I think Mike has said it at least 3 times already, but FDA's tobacco product regulation is civil, not criminal. And there's no jurisdiction in this country that has the authority to enforce the FDA's civil restrictions other than the FDA. And so any police interaction as a result of this rule would be illegitimate. Now, that doesn't mean it won't happen, obviously, but that's not something that the rule is establishing, right? Those interactions are going to happen no matter what the pretext is. And that is not to say that policing in this country is fine. There are definitely problems with it, but this is not something that's adding to that problem at all. The FDA's inspectors do not carry guns and badges. They wear white lab coats and they go into manufacturing facilities. So That could not be more of a red herring, and it's coming from the industry that manufactures the products and profits off of the disease and death, and they prey on the communities. So particularly egregious. And illicit trade is an interesting issue when you talk about federal regulation, because most illicit trade in the United States, it takes a form of legitimate purchasing in one jurisdiction and then the move and resale illegitimately in a different jurisdiction. And it's usually to avoid tax collection more than anything else. But when you're talking about federal regulation, that is coast to coast. And so, and FDA regulates the manufacturers. So there should be no menthol cigarettes coming off assembly lines because FDA should be inspecting those facilities. So the only way there can be illicit trade is if there's cross-border smuggling. And does cross-border smuggling happen? Certainly. But it's not going to come across our northern border because there aren't any menthol cigarettes in Canada either. So it's either ports of entry or the southern border. And I think we all could speculate that there are more profitable products to smuggle across the southern border and through ports of entry than menthol cigarettes. I have a hard time believing that the infrastructure that currently exists to smuggle things across the border is going to mean that people are going to be filling trucks and planes and whatever else with cartons of Newport for resale in the United States. Some will get through, I have no doubt. But the idea that there would be enough illicit goods to satisfy demand is just not even remotely true. It is incredibly far-fetched. Yes, and Joelle's right. FDA also has some amazing tools to address illicit trade. Hopefully they can implement a track and trace program at some point, which would essentially, I mean, that is the ultimate tool in terms of illicit trade. What else is coming through, Mike? Other big themes?
Where is it enforced on tribal lands? That's
a good question too. So the answer is probably yes. So FDA is regulating, well, probably yes in most circumstances. For this rule, probably in all situations. Because FDA is regulating the manufacture of the products, it's actually setting a standard for any commercial tobacco products bought and sold in the country. And that doesn't make a distinction between tribal land and non-tribal land. The FDA does have explicit authority to regulate on tribal land, which under federal law means that they can. If the law was silent on that, it would be an open question. That is not an open question. What this law won't touch still is sacred tobacco. And again, FDA doesn't regulate purchase, use, possession, consumption. It is uninterested with those things. It is the financial transactions, the commercial transaction of the buying and selling of products that FDA is interested in. So if you have a tribal manufacturer, tribal retailer, and they're manufacturing and selling menthol cigarettes, the rule would apply to that. There is no exemption for those facilities, even though they're on tribal lands. So they would be treated the same as a non-tribal manufacturer and retailer. That's a good question.
Another question I think that we should touch on is the issue of characterizing flavor. What FDA's working definition versus what we in public health would like to see it be.
You're asking me.
Yeah.
I was ready to listen to you say something brilliant. So yeah, I mean, I think that and we've started to think internally about what our comment to the FDA should look like. And I think that I really do think that I feel comfortable telling the FDA, abandon the idea of characterizing flavor and simply eliminate menthol entirely. There's less evidence probably about the sort of sub-characterizing flavor levels of menthol than there is about the characterizing flavor levels of menthol, but there's so much information and the logic from it simply flows, right? Any addition of menthol is bad. And I think also from just like a clean enforcement perspective, menthol shouldn't be in cigarettes. There's a whole bunch of other flavor additives that shouldn't be in cigarettes either, and FDA certainly should address those, but menthol is the lowest of the low-hanging fruit at this point. But I think that it is perfectly acceptable to offer in the alternative a definition of characterizing flavor, or some better way to do it than the sort of ad hoc approach. And FDA's authority is different than what, and enforcement resources are very different than what people have implemented at the state and local level. And so that, I think, as I said before, FDA could really just set the actual like chemical threshold. This is the amount by weight or by volume that you can put menthol into a cigarette. And I don't know what the number is, but as I said before, I'm positive that experts out there could tell you the precise amount that sort of crosses that threshold. So FDA is not stuck with the sort of sales restriction world that state and local governments have had to use. And I know there's been trouble, less in menthol cigarettes, it's more in cigars and e-cigarettes with the so-called concept flavors. And it can become difficult to figure out what has a characterizing flavor and what doesn't. But because FDA can regulate the manufacturing process, it has a wider array of tools than state and local governments have had. So that would be my advice to people who are considering how to comment on that issue in particular. I know I saw another question I wanted to get to.
Addition to what you just said, I mean, I think we should all be aware of what enormous power grant by Congress a Tobacco Control Act was. So FDA can do, I mean, can do these things. It's just there needs to be the will to do them, and so there's nothing that says they have to stick to their current definition of characterizing flavors.
Yeah, absolutely. I mean, I think, it really is hard to describe the depth and breadth of FDA authority. It is something unlike what most state and local governments would be able to do logistically. I see a question that I want to answer, and I'm going to take it a little differently than it's asked. And the question is about sort of lessons learned because of how long this took. And so I think one part of this that we intentionally glazed over, because like I said, we have resources that sort of talk about how we got to here now. And there are, the groups who are suing the FDA have done a lot of speaking on what they've done, but I don't think we really can undersell the importance of the FDA being sued on this issue. I mean, there is absolutely no doubt in my mind that there would not be a proposed rule today if people hadn't had the guts to sue the FDA for inaction on this issue. So, and I know that was not a decision that was come to lightly either. And so I absolutely applaud the African American Tobacco Control Leadership Council and ASH and AMA and the NMA, all the groups that are suing the FDA on this. When we filed the citizen petition back in 2013, it was something that we thought about for the future, but not in the most concrete way. And people had asked us over the years, like, how do we get the FDA to do something on menthol? And something in the back pocket was always litigation. But I think it is, I've talked about this before in other places and other times too, but I think we have a perception in tobacco control that litigation is an illegitimate tool when it comes to policy change, because the industry is so litigious and they use litigation in an illegitimate way. They use it to bully state and local governments. They will sue jurisdictions on legal ideas that they know are illegitimate just to muck things up and drag out processes. And so I think it is very easy in tobacco control to slip into the mindset that litigation is a bad tool. And it isn't. Litigation is something that is open to everyone. It is an equalizer. If your rights have been jeopardized by someone else, the courts are there and they're open to everyone. And so when you take that with the idea that FDA is the regulator and we're the public health community and we're all supposed to have public health as a goal, litigation puts you on the opposite side of them. And so it's hard to see what you assume is your partner in government and sue them for something that they have or haven't done. And so I don't think we can undersell the importance of litigation in this context, and other groups have sued the FDA for other reasons. And I think that if we're going to learn a lesson from how slow this process went, it is that litigation really can work. So we filed the petition in 2013. Nothing happened until 2020, and 2020 is when the litigation was first filed. And it took, I think, less than 12 months for the FDA to decide to grant the petition once the litigation was filed. So I really do think that's the lesson. And if you want to, go ahead.
Along those lines, I think as a template for, allies and others in this field, this twin procedures that are available, the citizens petition on the one hand, and then litigation, commenting and litigation, may be a template that others use to advance their goals and to advance efforts at tobacco control. And I think it behooves us to this model is a very powerful model. And like Desmond just outlined, you went from this citizen petition just sitting out there in the ether to having action within a relatively short amount of time, because it became part of a court's docket and under a court's supervision. And the court sets timelines for things to happen if you were to prevail. So it's a very powerful model, and I encourage all of you to take it and run with it.
Yeah, I was going to say that as well. I think I probably people aren't maybe super familiar with the citizen petition process, and we do have resources on our website, but you can request that the FDA take a particular action through the rulemaking process, and they actually are required to respond to your petition. So they have to read it and they have to respond. The response that we got initially, obviously, was sort of like, we're thinking about it, which isn't a real response, but it does certainly force the issue. And if the FDA doesn't give you a substantive response, you can take the FDA to court and force it to respond. And so the combination of filing a citizen petition and then suing the FDA for inaction might be the tool that we all need to move things forward at the federal level. The other sort of similar issue, or sort of similar like way in which we can really move things along that I think we sort of glazed over is the importance of the commenting process. I mean, that's obviously why we're having this webinar today, but I think it would be, don't conflate this process with other lawmaking processes. So I think we all probably, for the most part, feel fairly divorced from legislation, even probably at the state level for some of us, but certainly at the federal level. Things just happen. We probably can't really have all that much influence on the people who represent us. You can certainly meet with their staff and tell them your opinion, but they probably are going to vote the way they're going to vote. This process is very different. The FDA has given us its proposal, and every one of us can tell the FDA what parts of that proposal to change, what parts to remove, things to add. And the FDA is required to examine everything that you put before it. So that the open docket that sits right now on regulations.gov needs to be filled, inundated with information from the public health community. And the FDA has to scrutinize everything that you put there. And then in drafting the final rule, it is required to consider all of that. And the power there is that if there is enough evidence, enough overwhelming evidence that the FDA should take a particular action, and it doesn't, it puts out a weak rule instead of what we want it to do, that also is a cause of action to litigate. And I don't know exactly how that would potentially play out in this scenario. I'm not going to try and create a hypothetical, but getting all of the evidence before the FDA while we can change the process. I have seen proposed rules that were changed based on the comments, and I've seen them change for the better. So this is not a process that you should feel is just going to play out the way that it's going to play out, and maybe you submit something and it's a formality. It's not. It really isn't. I promise you. So this is such an important process.
Yeah, I think
I was just going to say we're getting close to time, but feel free to jump in on that.
Again, just an addition to what you just said. The comments are an evidence base that the FDA has. So if it were to be sued, these would be part of the evidence base, in addition to the decades of scientific evidence it has. This would be part of that base. That's why it's important. It's not, an up and down or a preference vote, but it's actually part of the justification for the rule. So that's why it's important that people comment with the experiences from their own communities, and you're not limited to one comment. You can submit as many comments as you'd like, and they have to read it and they have to take it into account.
Yeah, absolutely. And on our website, if you get yourself to the section on this rule and on the cigar rule, there's a short little video that we just put up that probably, if you're here, you don't necessarily need, but if you have other people you want to get engaged, it shows you how to submit a comment, like the actual click here kind of stuff. But it also, we tried to explain just what Mike is explaining, what does a good comment look like? And it really needs to be evidence-based if it can be. And what isn't evidence may not be exactly what you're thinking. I mean, this doesn't have to be peer-reviewed research. Your local level survey data, information that your coalition gathers from constituents, that's all data and it's all relevant to the FDA. So, but the more information, the better in all cases. I think in order to not take too much of people's time, I think we'll wrap it up there. I will say this was a lot of great questions, and I know we didn't get to all of them. I think we will try to create either some sort of, I think we'll try to create a publication that's sort of like a frequently asked questions. That's a lot of the stuff we talked about and the stuff we didn't necessarily get to. And if there are sort of issues that come along during the comment period, I think we could definitely have another webinar, kind of just like this one, to answer the other sorts of lingering questions. So keep sending us your questions, keep talking to us. We're doing another webinar tomorrow that'll be focused on the cigar rule. So all of your questions about that we can answer tomorrow. Feel free to email us, call us at any time. We are here to help you draft comments. We can look at draft comments that you've written. We can answer any of your questions about the process or about the substance. So thank you for joining us so much, and have a great rest of your day.
Thank you.